So welcome to Understanding the Basics of the Understanding Pennsylvania's Clean and Green Program, County Level Administration. This is the third program in the Clean and Green program series that we've done under this title here. My name is Audrey Thompson. I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. Next slide, please. The Understanding Agricultural Law educational series is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not specialize in agricultural law. This series is sponsored by Pennsylvania Department of Agriculture's Ag Business Development Center, established the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term vitality of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through grants and low-interest loans. Next slide, please. We've covered numerous topics under the Understanding Ag Law educational program, including ag labor, finance, conservation programs, this program here, Pennsylvania's Clean and Green, and many, many more. You can find materials and recordings of all of those programs on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. Next slide, please. We encourage you to mark your calendars and register for our upcoming programs. Under this heading here, Understanding Agricultural Law, we've got ADA compliance for agritourism operations on July 25th, and then foreign agricultural land ownership laws on August 22nd. Both of those are on Friday at noon Eastern Time. Attorney CLE is available for each program, and you can register from the Understanding Ag Law landing page or on our events page at our website. Next slide, please. We've also got our next slide. We've also got our quarterly dairy legal webinar series. Our next webinar under that program is going to be Tuesday, July 15th, and that program will cover the second quarter of 2025, and the focus topic will be the 2025 Federal Milk Marketing Order Reforms. That program is also at noon Eastern Time, and Attorney CLE will be available for that program. Next slide, please. We are also excited to announce that we have teamed up with Penn State Extension to offer education and services through the AgWorks program, which is funded 100% with federal funds from a U.S. Department of Labor grant totaling $1.3 million and 0 non-federal funds. This two-year program aims to link agribusinesses to workforce services, educate workforce professionals about the needs of agribusinesses, provide services and training to individual agribusinesses based on needs, and help small agribusinesses grow and succeed. AgWorks will provide 100 registered small to medium-sized Pennsylvania farms and agribusinesses with no-cost training and consultation to ensure business sustainability in the areas of hiring and retention, business operations, compensation and benefits, legal counseling, that's where we're going to come in, health and safety, and then PA Career Link services. Additionally, the program will register 1,000 agribusinesses in PA Career Link online system. If you are watching this webinar and you know a PA farm that would benefit from this program, or maybe you are a PA producer who could benefit from this program, please visit the website here in the chat and share the contact information. There's a survey you can take to be contacted by Penn State Extension. Refer ag businesses to this program and send referrals or questions to agworks@psu.edu. And then one last plug, I'll put this in the chat here. Next slide, please. One last plug, registration is now available for our 2025 Pennsylvania Agricultural Law Symposium. That's going to be Thursday, September 18th in person here at Penn State Dickinson Law in University Park. Lunch and refreshments will be provided. We're going to do 6 attorney CLE offerings will be available that day. Our tentative topics include ag labor, Pennsylvania's acre right to farm, environmental and natural resources, agribusiness issues, and 2025 ag law update, and more. Still working on the final program there, but we do have early bird registration available until August 29th. It's going to be $150 for attorneys requesting CLE, $100 for non-attorneys, and $25 for students. So do not delay. Register for this great event today, and we hope to see you here on campus at Penn State in September. And next slide. Okay. Finally, just a few reminders before I turn this webinar over. We are recording this. If you have any questions, please put them in the Q&A feature, and I will collect them and ask them at the end. We encourage you to fill out the poll at the end of the webinar. Tell us what you liked, where we can improve, and what topics you'd like to see in the future. And if you're interested in CLEs, I just put a link to the CLE form here in the chat, and do it again. You need to fill out this form to get your CLE credits. We can also send you an attendance certificate if you're out of state. We don't guarantee out-of-state CLE credit, but we will send you a certificate. And as part of our responsibility to ensure attendance, we will provide a code word later in the program that you must enter into that form. If you're on the phone, send me an email, AET17, and I'll send you the form. That's Alpha Echo Tango 17@psu.edu. All right, without much further ado, next slide.
There we go.
Or maybe even the next one is even better. I'll turn this program over to Brooke Duer, the Center's senior staff attorney. Brooke joined the Center for Agricultural and Shale Law in 2019. Prior to coming to the center, Brooke served as chief counsel to the Pennsylvania Department of Agriculture, and before joining PDA, he practiced law in Lancaster County for 18 years. Brooke, the screen is yours for understanding Pennsylvania's Clean and Green Program, county level administration.
Okay. Thank you, Audrey. I assume my microphone's working and everything's fine. I will proceed ahead. Okay, so we're going to talk about our third little installment of the Clean and Green series here, and this one's going to sort of concentrate on, not sort of, it will concentrate on the county end of things. So that's, I call it county level administration, which is kind of, could include a lot of things. But as we work through it, I'll try to explain how I sort of narrowed it down. That's me, and there's of course my email address. That's why I put this slide in there so that you can jot that down, send me emails on this topic or any other topic. That's what I love to do. So please go ahead and ask away. That's what we're here for. Okay, now this is our third, as Audrey said, and I said, and here in the PowerPoint, you probably, if you've ever seen my webinars, I try to pack a lot of stuff, a lot of links at least into the PowerPoint. So these, everything that's in blue and underlined here is a link to, here is the first two installments in our series with the PowerPoints linked here and the recording so you could watch them. The first was just a general overview, basics of Clean and Green. And that was the beginnings. And then the second installment, and that was, interestingly, look at the dates of these two. One was on 2/24/23 and one was on 2/23/24. So the second one was last year, and that was on Clean and Green separations and split-offs, which is the term of art that is used in the law for things where you're potentially conveying properties that are subject to a Clean and Green restrictions, or they're enrolled in the Clean and Green program. And so it was about the abilities and how you do things, and what kind of exceptions exist for those types of things, and leasing and subdividing and selling enrolled land, what it also talked about was all of the miscellaneous exceptions in there, because that's kind of where split-offs and separations come from. Is some of them result, if you do them a certain way, they result in they result in no financial penalty or problem with the Clean and Green enrollment, and the property continues on. And some of these things end up resulting in a rollback penalty, where some of the previous tax savings has to be essentially paid back to the county taxing authorities. So anyway, we're not going to talk about all of the exceptions to eligibility for lands that are enrolled in Clean and Green. In this program, we're going to talk more about, what does the county do, and some of the procedures and processes that a county files on that end of things, which is, I think, very good for, general practitioners to get that flavor too. because a lot of times, you don't really, you need to know those nuts and bolts of like, oh, well, what kind of form do they use for this? And, all that sort of stuff. So we're going to look at some of those. So before we do that, we're going to just do a little bit of catch up to bring everybody up to speed with some of the concepts and things. You can't really start in from scratch here without having, or start in cold without having the little bit of rundown. So here we go. By the way, this is a resource that's available on our website. This is our Clean and Green virtual resource room, and link to it is across the top. And we have tabs over here on the left where the statutes and regs are there, and then there's various case law and then related publications. And so this is just a general resource that you can find out and look at to get access to the statute and other things related to clean and green. Okay, here's the basic program overview, of course, and with links to lots of things. Here's the statute, and here's a nicer copy of the statute. In parentheses, I have the easier to read copy. Those are copies that were actually prepared by the Office of Chief Counsel at the Department of Agriculture, so they're still on the PDA's website actually. So there's the statute, and of course, it's not called Clean and Green; it's called the PA Farmland and Forestland Assessment Act, enacted in 1974. Then here's the regulations, and here's the link to the regulations. Like all ag regs, it's in 7 PA code. But of course, as you see with the statute, that's in Purdon's Title 72, which is the tax provisions. And so there is no way around the fact that the Clean and Green statute is a tax code. And so it's as boring and brain numbing and convoluted and circuitous as any tax code that you may read. So not a pleasant experience sometimes to read parts of the statute or the regs. This is a statute that has gotten into the form that it is because there have been lots of amendments over the years. This is not one of those statutes that is sort of considered like maybe a third rail, and you don't want to. The legislature doesn't want to touch it too often because things might get a little bit out of control with people trying to amend it this way and that. Amendments to Clean and Green happen all the time. And it's been tweaked here and there a lot, and some of that explains why it's a little difficult to piece together. But it's certainly a wildly successful program. It's one of the most wildly successful, programs probably, in terms of participation numbers. This is, a rousing success story, at least for those who are getting what the term of art, a preferential tax assessment for ag uses and forestry uses, etc. Okay, PDA, as the Department of Ag, of course, does have a role in this, but it's, we're here to talk about the county's role because that's really the people who do it all. PDA has a very limited role. Here's a link to PDA's website. And they do annual reports every year. The most recent one that's on their website right now is the 2023 annual report. I'm thinking there's probably the 2024 is out, but it's not up on their website. Because I think this says published in March of 2024. I think that's generally the right kind of time frame. It probably the next one that the 2024 annual report probably came out in March of 2025, just a couple months ago. So, there's one key provision in the in the statute that deals with what the Department of Agriculture is to do, and it's a bit of a loaded phrase. It says the department shall promulgate rules and regulations necessary to promote the efficient, uniform, statewide administration of the act. And boy, that's a lofty ambition because you're dealing with 60 separate county programs with 60 separate tax assessors and 60 separate boards of assessment appeals. And that's kind of how the assessor's office or a tax assessor's office works in Pennsylvania. In the county code is that the tax assessor is kind of the the day-to-day staff overseer and actual doing the day-to-day work, and then the Board of Assessment Appeals is sort of the quasi-judicial entity that the assessor to some degree serves, or at least his staff does. And then they make certain decisions, and the statute sort of does do a little bit of dividing between whether the assessor does a certain thing or the Board of Assessment Appeals does it. And of course, the Board of Assessment Appeals is the initial appeal forum from anyone who wishes to appeal an action of the assessor. So now trying to promote the efficient, uniform, and statewide administration of this act across essentially what it consists of 60 different entities who are all charged with the same responsibility, same statutory wording, but like anything, it's not always complete, and it doesn't have all of its blanks filled in, and there's lots of gray areas, and there's things that don't necessarily get uniformly administered across the state. And if there's anything you learn out of this today, is that that's exactly the case, is that there is variability sometimes, and much of what goes on in this area is people complaining perhaps about decisions or things that they've been told about how their clean and green application may be handled, or other decisions that come out of the assessor's office, and saying, like, that, well, can't the Department of Ag tell them what to do, and that they're doing this wrong, or there's the perception or something that they're doing it incorrectly in some way? And no, that is not what the Department of Agriculture can do. The Department of Agriculture can only attempt to promote uniformity and consistency across the 60 different tax assessors' offices that are involved. And it's not easy. We'll put it that way. Now, the county assessors, of course, this fourth bullet point here, they administer the program. So the let's see. Okay. Oh, I see. The language that's right here is actually after it says County Tax Assessment Office administers the program. It's actually reciting what PDA is to do, which includes distributing the annual use values that are used to determine the clean and green values each year. And one of the cardinal rules in this area is, of course, that counties can always use lower use values than what are provided from PDA as per the statute to the participating counties, but they cannot go higher than the use values provided by the state. So it's the use values are, to some degree, I guess you could call it a ceiling. Now, we don't have all counties participating. 60 of our 67 counties have elected to have a clean and green program, a preferential tax assessment program for certain land uses, which we'll see in a second on the next slide. But there's the list of counties that do not have clean and green programs. And some of them, that's because their real estate values may not be all that let's just say the market isn't that high to begin with, and so therefore offering the reduction may not really result in a whole lot of savings in some of these counties, because real estate values just aren't that high in comparison to other counties. Let's just put it that way. So that's now, some of these counties might kind of surprise you, though, that don't have programs. All of them probably have a history and a reason, and that's just something that's probably have to be very difficult to discern in each individual county because this all goes all the way back to 1974. Okay, now why do we even have, or how do we even have this? Because we all know somehow that there's this, uniform taxation clause in the PA Constitution. Well, here is the actual clause, Article 8, Section 2B1, that actually provides that there can be a form of non-uniform taxation in this particular case. And it talks about private forest reserves, agricultural reserves, and land activity devoted to agricultural use. And those are the areas where special provisions for the taxation and essentially a form of non-uniform taxation can be created for those particular uses as per the Pennsylvania Constitution. So that's how we have this program at all to begin with. And I don't know the date of this amendment to the Pennsylvania Constitution, but I will make a wild guess and say that it probably had something to do with the late 60s, early 70s as a precursor to this statute. Maybe it does go back a little further than that, but those terms are the terms that actually appear in the statute itself, forest reserve, ag reserve, and ag use. So you can probably see where all this is going. I think this all preceded the enactment of the statute by a fairly short period of time. Now, the basic overview, as we know, is that you apply for it and you can potentially have a reduction in your property tax assessment, ultimately, coming from the county, and then coordinated through the various taxing authorities, which generally uniform where most of us live. And obviously you have your school tax, and then you may have one or two others, depending on where you are. And then so you get a tax bill essentially that is based upon the use value rather than fair market value. It's not the highest or best use, excuse me, or the fair market value of the property in its highest and best use. It is the value of the property as it is in fact being used now. And that is generally going to result in a reduction for the categories of property involved, and is something that does have financial impact on the taxing authorities, no question about it. It is reducing to some degree, the tax revenues that are generated by property tax by offering this. So, certain counties perhaps have opted not to be a part of it for that reason. Is that they don't want to be shorting themselves on tax revenue, and I don't say that flippantly, but that is essentially what the program does. And school districts are not big fans generally of it because it is shorting them the most, since they are the highest tax rates for property tax. Now, the way that the use values are determined is a complicated thing, which we don't really need to get that far into. But instead of using, fair market value and comparables and highest and best use and everything, it's just an income approach to, okay, what do we do? What is this land actually being used for right now? And then, essentially going from that point to determine what the use value may be based on what kind of income can be generated from this property. And the two biggies, of course, are agricultural use or forestry use, and then there's this ag reserve that we'll talk about in a little bit. Not actively being farmed, but isn't necessarily incapable of being farmed. Let's put it that way. Right now, from the latest Bureau of Farmland Preservation annual report, which is I'll just that's the one where I don't have the 2024 version. The total enrollment is, over 10 million acres and about, close to 220,000 separate parcels. The average reduction in fair market value, or fair market assessed value, is roughly 50%. So that's a very significant tax savings for those people who participate in the program. And you can see that the counties are also spreading that across their no question, their revenue, their tax base is or their collections are going down if they are participating. Now, these are the three categories, and a little bit of information about the three categories of land use. County participation in landowner enrollment is voluntary, of course. No one has to do this, just like the counties don't have to do it. It's a voluntary program for the participants also who enroll. And it requires at least a minimum of 10 acres for agricultural use, well, for all three actually. But you can have less than 10 acres for agricultural use if you can show the ability to produce greater or equal to $2,000 in annual farming income from whatever commodity you might be cultivating or producing. And that's not a high bar. So now in the ag use category, there's about 4.4 million enrolled acres. The other qualification that gets overlooked a lot of times in the ag use area is that it also has to be devoted to ag for the preceding 3 years before enrolling. So, a brand new farmer or a startup operation, you got to have a little bit of a track record before you enroll the land. So that's an important consideration, and it's important to sort of understand that because that gets lost in the shuffle a lot of times. Ag reserve is for non-commercial open space land that's used for recreation or scenic enjoyment, and that is supposed to be open to the public, free of charge. Now, it can't have a home on it. So a lot of times you have people who just have undeveloped lands with wooded and other, undeveloped portions, and then they have their house sitting in the middle of there. And it's, a 10 or 11 acre plot, let's say, with a nice big old house. And it's given rise to what people refer to sort of informally as the McMansion problem in this particular program, which is that as conceptualized, I don't think that people really thought of the ag reserve category as something where homeowners would be enrolling, a big spread that they may own of 10 acres or more, that is essentially just their home. Then this whole concept of, and that is, it is open space that is being used for scenic enjoyment, scenic enjoyment of the homeowner. But the other sort of snafu in all of this is the open to the public free of charge. And that has caused some consternation with this category. The ag use, everybody understands, what that's all about, giving a tax break to somebody who is farming. The ag reserve category is not as well understood. Obviously, much less in terms of quantity, 608,000 acres enrolled. And then the forest reserve category is for lots of 10 acres or more of forested land capable of yielding timber or other wood products. And that's pretty broad and pretty not a particularly high bar to meet there. And of course, the northern tier of the state has, just massive enrollments, and we'll look at some of that. Okay, again, these are the counties that don't have programs. I already had a list of those, and again, each has their own reason. Here's a little map. This is a little older. This is a map from 2020, but it's the last time it was done like this, and it shows you essentially the darker and the bluer the color. I should say the bluer the color because the gray is the darkest gray is non-participating counties. And Philadelphia has a program, but they're in gray here because they just didn't report in the data that was used for this map. So there's 7 counties here, 1, 2, 3, 4, 5, 6, 7, and then there's Philadelphia because it did not report. But Philadelphia, again, does have a clean and green program. And now you see the dark blue, that's obviously the heaviest uh, enrollment, by county, so to speak. And it does match what you would think of, is the, forested counties up at the top are heavy users of the program. A couple of selected other, counties like Clearfield and Center County, very heavy, Somerset, Washington, Bedford. And then you sort of get into, the heavier farm areas, Adams, York, Lancaster, and Berks and Chester to a degree. You look at Montgomery County, which at one time, was a extremely heavy ag county, but this is, its heyday had passed before this statute really got into gear. And so it does not have the kind of participation. Interesting, because there's still farming going on there, and their real estate prices are obviously very high. So this would be a very beneficial program to them. In any event, here's a couple counties, and we're going to look at these counties later on in this presentation. I picked 4 counties to look at because some of them had interesting aspects to them. For example, Clearfield County and Bradford County are just 2 versions of the same thing, which is a forested county, heavy on the forest reserve, or the forest use, I should say. As you can see some of these numbers in here, hopefully they're not too small for you to see. Clearfield County is just amazing. This participation number for Clearfield County is just stunning. And of course it's all in forest use there, or the lion's share of it is there, but they have their share of the ag reserve also. And then ag use lesser, obviously, than Bradford, very big in ag use and not as high numbers in, forest use, pretty high numbers in ag reserve. So that's an interesting kind of, distribution for a northern tier type of county. But total acres, very, very high. And then you have Lancaster, which is sort of the farming hotbed. So that's a distribution you'd expect. Lots of ag enrolled properties, not so much ag reserve, very small ag reserve. And, some, but very small, forest enrollment there. And total acres, a very sizable number if you didn't have Bradford and Clearfield to look at by comparison. And then you have Chester County, where you have very high real estate values and farming going on simultaneously, and worse, sort of a much bigger spread, or a much more let's just say high-priced real estate market than Lancaster. And but with farming going on, and they have an interesting distribution here too. About what you'd expect, except 0 ag reserve. And maybe we'll talk about that a little bit later when we look at some of the information about those specific counties. Obviously this, clean and green is a policy choice. I'm just looking at the time here. I got to get going here. To essentially forego some tax revenue for the purpose of benefiting these particular land uses and encouraging these land uses. But that doesn't come without some detractors. Okay, so there are, this is the basic mechanism that, and people call it a clean and green, the covenant of the program, which is in exchange for these tax savings, you promise to do something as a landowner. And what you're promising to do essentially is to keep it in that land use for perpetuity, for as long as you're going to get that tax break. And then if you break the covenant, if you develop your land in some way, engage in a use of the land that is not compliant with the program, you get assessed a rollback tax, which is your last 7 years worth of tax savings. Or if you haven't even been in the program for 7 years, you'll just have to pay back all your tax savings. Once you get to the 7-year mark, then it's just the last 7 years is what you have to essentially pay back to the county if you change the use. So that's how it incentivizes the continuation, theoretically in perpetuity of that particular use. And then there are many, many exceptions. Rural enterprises, that's why many farms and many properties that are enrolled in Clean and Green have other things going on that are not just farming. If they fit this definition for rural enterprises, that's a big, area of things that are allowed to be done on a Clean and Green enrolled property. Split offs and separations are where you do different things, sometimes to sell off a small parcel to make some extra money, sometimes, for other reasons. You're doing something, subdividing, rearranging property lines, combining deeds, selling properties, all of these things, they may qualify for no rollback, even though it might be a change of use because they're allowable as a split off or a separation. And those are terms of art which we talked about at some length last time in the last one. Now, of course, the restraints on the free alienability of the land, this is are there. The obligation and the covenants of being enrolled in the program, that you're going to keep it in that use in which you enrolled it, without violating any of the requirements of the program. That runs with the land. So somebody can buy your farm and they just continue to be enrolled in Clean and Green, and there's paperwork that goes on at the closing that essentially they sign on the buyer signs on to continue the the participation in the program. They have no choice. If they want to buy the property, they have to buy it subject to the Clean and Green covenants that are recorded in the chain of title here through the enrollment in this program. So we'll talk a little more about all of that. And there are some people that, of course, will develop land that's in Clean and Green regardless, because the cost of, whatever the rollback tax, may very well be for them just the cost of doing business. And, we've seen some of that with the solar leasing that's going on in the state, where the solar companies will come in and, a commercial solar generating facility that's going to be providing electricity to the grid is not a permitted use on a Clean and Green enrolled ag use or forest use or any of them, any of the categories. But having to pay back 7 years worth of tax savings might still be worth it to the solar developer who by these leases that are going around, needs to obviously be required to pay that, not the landowner. It's the solar company that's causing the breach of the covenants in the program. So that's key to these solar leases. And of course, the other aspect of getting the rollback is that your property gets kicked out of the program, and you no longer get the tax savings. Now, there is a possibility to re-enroll that which has not been developed, but in other words, if you have 100 acres and you end up developing 30 of it, your entire 100 acres that was enrolled gets kicked out. You might be able to re-enroll the 70 that's left in your possession, or is left to, and is still eligible. The tax break on that, 30,000 is gone forever because it's no longer eligible. You developed it in some way. So, and it's a pretty draconian, rule, because if you enrolled 100 acres, a change to 1 acre that violates the program could very well amount to, or could result in a rollback of the tax savings, and having to regurgitate all of that on that tax savings for the entire 100 acres. So the trick is, it's not really how to get in the program; it's how to stay in the program once you're there, yet still enjoy the fruits of your land ownership, so to speak. Okay. Voluntary removal is in fact allowed now as of 2010. It was a revolutionary concept at the time. For most of the history of this program, you couldn't just go to the county and say, you know what, I want out. That's not how it worked. You basically had to kind of do it and then get kicked out. It was, excuse me, and you would self-report to them that you're changing the use, and then they would give you a rollback tax bill. But you weren't doing it voluntarily, or I should say, you weren't asking for it, but you had obligations under the statute to report to them changes of use. Anyway, the one thing I want to point out is that in these solar leases, if in fact the solar developer wants to just go and have the acreage voluntarily removed, the little problem with that is that you can't re-enroll any of that property that has been voluntarily, requested to be, taken out of the program. And of course, if you voluntarily request to take it out of the program, you will pay the rollback tax. And then if you do it that way and you pursue this way of doing things, you can't re-enroll any of it. So if you had 300 acres and 100 acres went for a solar farm and you had 200 acres left, you can't re-enroll those 200 acres after, this transaction goes down because of the way this is written. So it's kind of, the idea that you basically you essentially self-report yourself to the county and you wait for them to assess you the rollback tax is, still a much more advantageous way to proceed, precarious as it may sound. Okay, now, there's a ton of exceptions for all kinds of things that you're allowed to do on clean and green property. We talked about that last time. That's why it works so well, because it's flexible. It has lots of ins and outs, lots of nooks and crannies, lots of things that can be done. And again, we're not going to go over all of that. Some people would say that the statute has been too far, it has been altered too much. And that, the exceptions have sort of swallowed the basic rule. Well, that's for somebody else to judge. All right, I'm going to go forward here a little bit, and I am going to skip over. I'll tell you I'll go over one thing just by using this visual here that I'm going to set up in a second. There is an allowance in the ag use category for essentially subdividing off 2 acres for a residential lot every year, up to, you can do that 5 times for a total of 10 acres over the life of your property's enrollment in clean and green. You can essentially subdivide off 2 acres 5 times, or 10% of what the entire tract is, whichever is less. So that's kind of the limitation on doing that, but it produces something visually that we've all seen, which is farm back here, fields all around, and where's all the little subdivided lots? Right here, right along the road frontage. Yes, they need to be on the road frontage because they need to have driveways, but this is the exact product of the clean and green 2-acre exception for, what's called a 2-acre residential split off. And so this is the visual evidence of this program, exactly what it produces out there. You see it graphically right there. Okay, and it's a rollback. It's a modified rollback. When you do this, what this farmer has done here, you only pay rollback on 2 acres. All the rest of your land stays in. All this land stays in, and all these little lots, you just pay a rollback on the 2 acres. And generally that's affordable, and it still becomes, a income generator for the farmer, because you're only paying the tax savings that you realized for the last 7 years on 2 acres. Okay, now let me just keep going ahead. I want to make sure I have plenty of time to do what we need to do. Okay, a couple of notes on enrollment, and then we'll talk about some county issues. And these are really the county issues, is that how you enroll and the application process. This is directly out of the law. a landowner may not enroll less than the entire contiguous portion of land described in the deed. That's an important sentence, which we will talk about more. But that sounds like, okay, so you have to enroll everything that's on your deed. You can't pick and choose if it's contiguous. You have to enroll it all. Well, a lot of people don't have contiguous. They got something going on there that, is probably, not going to be eligible for one reason or another, such as like a driveway. A driveway isn't technically in ag use, so lots of little areas around a property aren't necessarily in ag use or capable of being in ag use. And I'm going to talk ag rather than forestry just because that's what I do most of the time. So any event, this is an important thing to grapple with. And this is one of the things I want to talk about here. You can combine contiguous acres from multiple deeds because they're contiguous. You can actually apply and enroll land that's on multiple deeds as long as the total enrolled acreage meets the eligibility requirements and the use does, then you're fine. But sort of the converse of that, is that you cannot split up contiguous parcels that are on one deed. They must be enrolled together. You can't divide them, so to speak. Now, we'll talk some more about that, but in any event, and you can also add little parcels if you have something that is already over 10. You can add things by amending an enrollment and adding a few more acres here and there, and they don't have to be 10 acres to essentially supplement an existing enrollment. You can have more than one use category on an application. The county works on the basis of an application and what land is in that application. And these are the kind of the rules for that the interpretation of, or I should say maybe the choosing and the filing of an application. What lands are you going to file for? Just another little issue is recreational activity, whether it's for a fee or not, like trails and snowmobile using and and ATVs or whatever it might be, that kind of thing on ag or forest reserve property, forest use property I should say, does not disqualify the land as long as it's not rendered incapable of immediate conversion to ag use. So if you're paving something, that's not going to work. But and it's not it's not being rendered incapable of producing timber or wood products. And so, recreational activities are okay. Let's talk about county administration issues. Okay, again, it's the enrollment process is what the county is, and this is the end of it. This is the side of it that everybody talks about all of the other issues in clean and green, but like the enrollment process and the application process and what's in it, and that's not a side of this that's really seen very often. So that's a big part of the county, and is the enrollment and applying the criteria. They're not writing the criteria. The criteria is in the statute for the most part, but they are defining how the application or what application they're going to use, and I'll talk about that in a second, and essentially the way in which they're going to administer it, and they're also they have an interpretive decision to decide is this land eligible, how do we apply this law to the facts, etc. Okay, they are responsible completely and totally for the termination of properties from the program if they change the use or if something happens, that makes the land ineligible to be in the program. In other words, involuntary termination, assessing a rollback tax and booting land out of the program. And then, of course, there's an entire internal procedure in the county at the county level for getting notice of all of that and getting the right to appeal all of that. And the appeal process goes from you get your assessment from the the assessor, then you can appeal that and your assessment of a rollback, in other words, and that you're getting kicked out of the program or some acreage that you own is getting kicked out. And then you appeal that to the Board of Assessment Appeals, just like any other real estate property tax appeal. It's the same process from that point forward. It's because you're appealing an assessment. It's an assessment of rollback taxes that carries with it, that you're being terminated from the program. Now, they're in the statute, and I got all the sections here. There's a whole section about the application. And one of the things having worked at PDA as long as I did, I was I never really plumbed the depths of this one. But apparently back in 1974, everyone had this idea that there shall be uniform application forms for preferential assessment in all counties. Well, that is not happening. Such application forms shall be developed by the department. I've seen some evidence that that did happen once, but that's technically not how it goes now. The counties use their own forms. Of course, they've all been with these counties for decades now, and some they say different things. They are not uniform application forms across the state. In addition to the basic information about the property, this is like the little Miranda warnings that are right in the statute. They have to be on the application form, and it's basically the Miranda warnings to tell you that that if you first, we can just go through it. It's okay. If the application is approved, then you submit 30 days notice to the county assessor anytime you have a proposed change in use of the land, change in ownership of a portion of the land, or any type of division or conveyance of the land. Does the landowners comply with that uniformly? No, they do not. And that is a big issue there. You are supposed to be self-reporting everything you're doing that changes the character, use, ownership, leasing, etc. Anything, that changes the various things that come into play in the program. I guess I'll say I should probably have a better phrase for that. But in any event, you're supposed to self-report all of that stuff. That doesn't necessarily happen all the time. Sometimes, assessor's office finds out about, an assessor's office finds out about this through, the grapevine, or, driving down the road and seeing something, and so that's it. Couldn't be a problem for sure. So let's keep going. Number of other things in here. Landowner, is supposed to submit 30 days notice. Again, that was what I had, it was in the Miranda warnings, and, that you're supposed to be filling out these forms and sending them in and, reporting and self-reporting these things. It's not really, probably, it would be interesting to talk to some assessors and find out, how often that really does happen. It's a little bit of, probably a game of cat and mouse trying to, sometimes pin down what's going on at some of these properties. And, you get neighbors calling and, reporting people for this and that and the other thing. Let's see what else we would need. Another important thing to understand is that because there's so many counties that are behind on their countywide assessments, in 2016, they essentially imposed a rule by amendment to the statute that every year use values come out and they may go up, but the counties who have not done a countywide reassessment as of 2016, a county's use of the use values is frozen, and they cannot use any of the new use values that have increased until they do a countywide reassessment. So it's an incentivization of getting countywide reassessments done here. The countywide assessor obviously, has to keep all the tax rolls, notify all the taxing entities in the county of the changes. And you can see if I shouldn't say no one, but if a lot of people aren't self-reporting, then the information that's in the system is bad or old, and the taxing authorities, whether it's a borough or or a county or the school district or whatever, the information that they have is old and outdated. So, that's a problem, in terms of, and I'm sure these county assessors work, as diligently as they can, but it's not necessarily perfect. I'll put it that way. Okay. I'm going to keep going. And the let's see here. What I want to probably just jump to the next one here. Basically, the obligation to pay back the rollback taxes, in other words, to pay back your county for the tax savings you got for the last 7 years, that technically starts on the day that you've changed the use, whatever it is that you're doing. But if you're not having people self-report, you're missing that, and you end up sometimes having a situation where a rollback notice comes in, and it's sort of retroactive to 1.5 years ago when you built this building out there and didn't self-report. And the interest, there's a 6% interest on the rollback taxes from the date of the change of use too. So, if you don't self-report, you're kind of hurting yourself as far as, that goes, because you're going to get a much larger bill, at some point down the line. Now I want to, let's see if there's anything on this screen that I want to make sure that I cover. Obviously, the county's responsibility is to handle all the appeal process too. Now, this is really key to this, which is there's the basic rule, and I said it once, which is that all contiguous lands on one deed must be enrolled together. And here's the definition of contiguous, tracts. And it says it right here. A landowner may not apply for preferential assessment for less than the entire contiguous portions of land described in the deed applicable to the tract for which you're seeking the preferential tax assessment. So that is quite, that's kind, because who has, let's say you have 100 acres. There are going to be plenty of portions of that are not in the use for which you are going to apply, because it's a road, or it's your driveway, or it's something else, or it could be any number of things, dilapidated buildings on the back end of your farm somewhere, or something that is not in an ag use, not going towards the production of any commodity. But yet it says here that you have to enroll everything. You can't sort of, you can't parcel it out or parse it out. So that's sort of inherently confusing. And that's the way the statute is written. Well, what happened is, essentially, long story short, in the regulations many, many, many years ago, way before I was at PDA and way before anybody who's there now was there, somewhere in the 70s, probably, they came up with this idea they created a new concept, ineligible land. And that's all that stuff on your 100-acre farm that isn't actually devoted towards the production of an ag commodity. And so now that this is how the countering of that sort of rule that talked about everything, all your acreage on that deed, has to be enrolled at one time. And you can't, pick and choose which portions of it you want to enroll. Well, this ineligible land concept gave the flexibility to the program to essentially say, okay, we can draw boundaries. They're not going to be subdivided boundaries. They're not going to be real boundaries, but they're going to be, maybe you have 100 acres, but only 82 of them are devoted to the actual ag use, and you have 18 miscellaneous acres here and there that aren't actually part of the ag use. And there's a whole issue of it, depending on what category you're in, whether the house, if you're living there, the farmstead, and that's what they call it even in the forestry situation, whether that is, carved out also, and you don't get the tax break on that. So for all the things that aren't capable of producing an ag commodity and aren't part of the use for which you're enrolled, they get carved out as called ineligible land. And that sort of solved some of the issues. At least in terms of conceptually, it solved it. And there's an example right here, but you know what? It being 1 o'clock, I want to just go right ahead. Now, what I have here in the remainder of this PowerPoint is I have a number of examples of the 4 counties that we talked about before and what their forms look like, their application form, and if they have any documentation that says these are the requirements for enrollment. And the lesson out of all of this is that the uniformity that was being looked for in the statute across all counties is certainly not quite there. So as an attorney in the world, in practicing, you need to understand that you have to go and find out what your county does, what their forms look like, how they read, and there's a lot of variability from county to county. And in this PowerPoint, you can take a look at it on your own time. Chester County I have in here, and have some nice little excerpts of things to show what their forms look like, and they use different language, for example, than Lancaster County. And here's some of the forms from Lancaster County that, now, is it radically different? No, but it is different enough that, for example, this idea of you have to enroll all the acreage on your deed. Well, what if all the acreage on my deed isn't devoted to ag use? There's no answer to that unless you really dive into the regulations and discover this ineligible land concept, which is sort of carved out. None of these forms talk about that at all. So that is really one of the things that you have to master is, what exactly is my county doing? And because the state can't answer these things for you, this is purely a county assessor's office question, and they are the only ones who can answer it. Some of them have all their forms online, but even reading the forms, as I tried to illustrate by this sort of collection of forms, they're not going to help you either, because not one of these forms talks about ineligible land and how you deal with all of that. So that, Audrey, with that, I will go ahead and see what kind of questions we have. Let's see what we got.
All right, well past time. So this will also be recorded, put up on our website. So thanks everyone so much for joining us today. Thanks, Brooke, for a great presentation, great discussion, and have a happy 4th of July. And hopefully we'll see you on Tuesday, July 15th for the next quarterly dairy legal webinar. So thanks everyone.
Thanks.